Okay, good afternoon, everybody. I just want to thank Lynn and Colleen for having me come up and talk about these issues. These things are near and dear to my heart. They must be somewhat to yours as well if we're all here on a Saturday afternoon, so I appreciate you coming out. I have a presentation that I have ready to go, but I think this is a great size group to feel comfortable. If you have questions as I go, or if I say something that you want to dig deeper on, please just speak up and ask questions as we go along. The way I'm going to do it is, it says Law 101 for video creators. I'm going to describe a little bit about this organization that I run, New Media Rights, and the services that we might be able to provide for you. And then secondly, I'm going to talk a little bit about just general legal issues that you should have on your radar when you're making films. And it's not always the most glamorous part of making films, may not even be the most fun part, but it's a necessary part, and it can really make a difference between the film or the video succeeding or not. And also, so once we get through with that introduction, I'm going to talk about the basics of copyright law, and then a little bit about, and the whole theme today is kind of, when do you need to get permission from someone to use something? When do you not need to get permission from somebody to use something? And so we're going to talk about things like licensing. How do you go about getting a license for your music? If you're going to a music company and you're asking for a license, what kind of things would you say to them? How would you approach them? And then we'll get into fair use. And I've got some examples of some filmmakers that we've worked with right here in LA of fair use. And fair use is really all about, when can you use the works of others without permission? And fair use, that's what's amazing about it, is copyright is all about control. It's your ability to control and protect your work, and others' ability to control and protect their work. But fair use is a safety valve that allows you in certain circumstances, and particularly in the documentary world, to be able to reuse things without getting a license. And lastly, I was going to talk a little bit about Creative Commons and open licensing as just an option and something that's available to you. So first of all, and the reason I'm here, by the way, is I work with documentary filmmakers and video creators every day. I'm an attorney. I teach internet and intellectual property law at California Western in downtown San Diego, and I've been doing this for about 7 or 8 years. I started New Media Rights, and even before our services, let me just say what we're all about is this idea that over the last 10, 15 years, even 20 years, it's become much, much easier, as we all know, to create and to share online, whether that's videos and films, whether that's images, whether that's the written word. And so the idea was, how do we provide, and what I was interested in when I was coming out of law school was, how do you provide all those new voices with the legal services that they're going to need? And so that's what our organization is all about. And if there's one thing that you leave with here today, it's just know that New Media Rights is a source of free or extremely low cost legal services for your film and video work. Also, we do work with a lot of tech startups and other types of artists as well. So just so you know about us, first of all. And the three things that we really do are, first, one-to-one legal services. So that could be anything from, particularly for filmmaking, that's things like reviewing a film to see if the clips are fair use or not, right? If you have some really tough questions about fair use. That could be getting all the contracts ready for you when you're shooting a film. If you've got crew that you're working with, if you've got, if it's a fictional film, you got actors, or if you have even people that you're interviewing for a documentary film, it's really good to have the right releases that you need for that. There's been some recent cases actually that have even suggested that actors in certain situations where there wasn't a clear agreement between the filmmaker and the actor had some sort of copyright in their performance. And so it's really important to get all those contracts you need so that, even if it's a friend, even if it's somebody close to you, sometimes what happens is, maybe 99 times out of 100 there's not an issue, but when that issue does arise, it's as soon as the video or the film starts to have value, that's when communication starts to break down and issues start to arise. Sure.
You said so you can ask the question live.
Yeah, absolutely. Okay.
Well, for instance, I have a question about how, there was a movie where Michael Moore interviewed a guy on gun control.
Right.
a famous actor, and clearly the actor was not pleased with the interview at all.
Right.
And I don't see how in the world that guy would sign a release form. How did Michael Moore get the rights to these kinds of things that he uses?
Sure. Well, and that's sort of a whole, so you can get a release from somebody, and if you do get a release from an interviewee, you want it to be very thorough. A lot of times there are many sort of templates for these releases, and even video releases are a great example of to be careful with templates, right? Because 95% of that language might be perfect for what you're doing, but in every circumstance there might be some nuances. I mean, typically what you need with a release is things like the ability to advertise, right? But with that situation, he might not have gotten a release. And there are situations where you don't necessarily need a release, and there are some exceptions to that. For instance, there's a whole news reporting exception in California, for instance, that sort of carves out. And then there's also other exceptions that might allow for that situation. That area, I could talk more a little bit after the talk, but it wasn't something that we had planned to go into too much depth on. But in general, if you can get a release, it's great to get a release. But that's another thing where we can help. If you have a question, I really want to do this interview, but it's going to be sort of a hostile interviewee, and I need to know how I can handle it. One thing you have to be very careful about in California is not secretly recording is something you have to be very, very careful about, because we have wiretapping laws, which are basically, restrict you from doing that, but and with some very few exceptions. So one-to-one legal services, those kinds of questions we could answer. Contracts we could answer. Copyright review. If you're trying to license some music, we can help you get those licenses from various music companies. We can work with you on that. And then because we're a nonprofit, because this summer we passed our 1,000th client, but there's absolutely no way that we can take on everyone who needs free services. So what we do is, from what we learned, we create a bunch of guides that are freely available on our website, and you are welcome to access those. We have a whole FAQ on copyright, so if you want to follow up this, not only will I share this presentation with Colleen and the Doculink folks so that you all have a chance to access that, but I'll also encourage you to go check out our website, where we have about an hour-long FAQ on copyright, and we have extensive written resources, over 150 YouTube videos, which are actually pretty watchable for a nonprofit, I'm proud to say. Educational videos and guides, and we also do public policy work. So that means that we go to the Copyright Office, we go to the Federal Communications Commission, and we try to bring the stories of the independent creators that we work with, and also the kind of very small bootstraps tech startups that we work with, to the table of policy discussions where they usually are not. So we're an independently funded program. We're actually a fiscally sponsored, we're totally independently funded, but we're part of California Western School of Law, based in San Diego. So services that we provide, as I said, we can look at your film before you're going to send it out, see if it's fair, see if the way you use the clips is fair use, see if there are copyright issues, trademark issues. We can look at the contracts you've got and see if they're good to go. Also afterwards, once your video's out there, you might have the video taken down for some reason, right? And we'll talk a little bit about that, but DMCA takedown notices, the Digital Millennium Copyright Act, is a way, you might have seen videos disappear from YouTube and they say there's some kind of copyright claim. Well, that could be one of two things. It could be the copyright content ID system that is part of YouTube that automatically flags copyrighted content that's reused, or it could be a direct letter saying, hey, your content is copyright infringed, it's got to go down. And we can help you navigate that process, and that's actually one of the things that we're most well known for, is stepping in for a lot of video creators in free speech situations and making sure that they're able to actually stand up for themselves when, like, it's typically a larger company steps in and says, oh, you can't use this clip or whatnot, and helping them understand what their rights are in that situation. So basic legal issues that you might run into, we're going to look at quickly: pre-production, production, and post-production. Well, when you're pre-production, you're developing the film. Especially if you're in a fictional film, you want to, if you need the literary rights from somebody who wrote the book or wrote a script, that's something you get in a contract. If you're writing a script, or you're writing a script with a partner, or you're collaborating with someone, you've got to be really careful to make sure that the relationship is clear, that those expectations are clear. And you can do that by having a really clear contract written with that person. You might need to create an entity for your film, and that's something that you can work with an attorney on as well. Is it appropriate in your situation to start a separate company for the film or not? And that might depend on what you're doing. Financing, if you're getting somebody to finance this, what's that agreement? What is the agreement between you and the person who's financing your film? In production, there's a lot to consider. There's all those contracts that relate to all the people you're working with, like we mentioned, crew and interviewees. You might need a location agreement to make sure that the way you're using the location is clear and the expectations are clear there, especially if it's a private space. You may have music you want to use in the film. You may need various insurance on the film, both for the actual shooting portion, but also you can get something called E&O insurance, which I have listed on the last bullet there. And that's something, we're talking about fair use today. That is something that when you get done with a documentary film and when you go to an insurer to insure the film, a lot of times if you go to an E&O insurer, they will want an attorney to have written you a letter and to say, hey, look, for these 5 clips that were reused, that was, we think there's a great fair use argument for those 5 clips, and we think that you should go ahead and insure this person, and then the insurance company will offer the insurance. So that sometimes comes up. And then if you're producing the film and you're hiring a director, or if you're having somebody compose music for the film, those are all situations where you want to make it really clear who owns what. And well, why? Why do you want to make it really clear? It's because when you work with, and this is true both for filmmakers as well as small startup technology companies who hire software developers and video creators, most of the time when you're doing things, a lot of independent creators it's not a business where you're sort of everyone's an employee. If everyone's an employee, then the business just owns the work, and that's really simple, right? And then it's really easy to know, well, who owns it? Well, the company owns it, the film studio, let's say. But if you're not a film studio where everybody is an employee, then what happens is you've got a lot of independent contractors. And in the situation where you've got a lot of independent contractors, if you hire an artist, or if you hire a composer, or even if you hire somebody, frankly, just to hold the camera or to do the sound, if you don't get the contracts clear with them, there can be questions about who owns what. And you may have even run into this in producing your own videos and films in the past, but that is why you get these contracts straight up front.
I have a question on the location.
Sure.
Contract. Let's say you want to do shooting in a city, and let's just say it's not Los Angeles.
Right.
I guess it's a little bit more stringent in Los Angeles, but
right.
You generally need to contact the city and say that you're going to be doing shooting on the city, and then what if you end up doing some shots and you get well-known names in the footage as well, like a Starbucks or a McDonald's?
Okay, well,
so
there were 2 different questions that basically packed in there. One was, if you're shooting in a city, how do you sort of get permission for that? And then 2, if you happen to catch a number of trademarks, that is things like a Starbucks or some kind of trademark like that in your shot, what are the issues there? Well, as far as the first question, it varies area to area. LA has a very sophisticated film commission that centralizes the film permitting process. And so I was actually speaking more to agreements with private spaces, but permits are really what you're looking for. And you have to find out whoever permits in your area. Up here might be a little bit easier because LA is more organized with it. It's a little more expensive though. Down in San Diego, as just a contrast, the Film Commission actually has really stepped back in terms of its role. And so the permitting down there used to go through the commission, but now if you want a permit, you have to go to, you could go to the city police, you could go to, if you had to do military base, you go to the military police. If you had to do the airport, you go to the port police. If you go to a Native American lands, tribal lands, you would need to get permit from Native Americans, the law enforcement there. So there's at least, there's different, it depends on where you shoot. You have to figure out who the permitting agency is and work with them, and it can be easier or more difficult. The advantage though there, I guess, is that it's free, free down there. So that's the ups and downs, right? Okay, so then you get to, and as far as the trademarks issue, if you happen to catch something in a shot, I'm going to talk about this a little bit in fair use under copyright, but as far as trademark goes, look, the whole thing with trademark, period, is that you shouldn't be implying an endorsement or some kind of relationship with the product. Now, that's difficult in this day and age because I think we're getting a lot more conditioned, even from 15, 20 years ago, to seeing products in films and TV shows, and sort of, if I see a product in a TV show that's anything more than a fleeting, passing thing, I think that the product is probably somehow, working with the show just because of a lot of the product placement that's going on. So that gets a little bit funnier in this day and age. But the truth is, you don't have to falsify reality. If there's something critically important in that shot and you happen to catch, a trademark, typically it's not going to be a huge problem. But it depends on the situation. And certainly there have been some documentaries where there were trademarks that appeared in a shot, and it was a very poignant moment, a very strong moment where a point was being made, and it had nothing to do with the trademark. And we advised in those situations that it was, there was a few points where it just didn't make sense to even have it there because it was almost confusing to the story, and there seemed to be also some sort of strange relationship implied. So that's the kind of thing that we can help with though too, is whether or not the use of a trademark is appropriate or not in your film. Once you've got your film or your video complete, and a lot of what I'm saying today, by the way, I don't know how many people are trying to make films or trying to make kind of full-length feature type films. Okay. And are people also who's doing shorter videos, like YouTube channel type work? Okay, so there's some of both. And a lot of things I'm going to say apply to both, so I just want to make that clear as well. So once you've got your video or your film complete, you may be lucky enough to get some kind of distribution offer. And I can't highly enough, having seen these and spent many years looking at distribution agreements, I can't highly enough recommend, when you get to that point and you've poured your heart and soul into a film, particularly a documentary, because most folks I've worked with, it's been a passion for them, and some have done very well, and some, haven't done as well necessarily monetarily, but the idea is, it's this passion for them, and what I find is that once somebody gets offered a distribution agreement, it's easy for them to get very excited and to just, some of the normal things that we do in terms of checking and being sure about these agreements we get into become even more important. And so you don't want to just get excited that you have a distribution agreement and accept it. It's really important to have an attorney actually look at the agreement. And it's really important to understand what they're going to do for you. Because I have seen people sign away rights to distribute a film for 5 years, and then the distributor sits on it and doesn't do anything. So if you sign up with a distributor, I would just highly recommend you talk to an attorney and you get somebody who's actually gonna work for you, and that isn't just gonna have your film on the shelf and not try to really kind of move it and get it out there. And you might have different goals. It might not just to be about, you may want to break even and make some money, but it might be more about getting the film out there to the world for you. And so you want to talk about those goals with that distributor and make sure that they share those goals and are actually going to work on those with you. So now we're going to move into the basics of copyright, and then we're going to talk about, with those basics of learning why copyright is even relevant to us, how then can we use that to understand when we can reuse content and when others can reuse our content. So people have been reusing content for quite some time, right? I mean, when people were writing stories thousands of years ago, people have been borrowing stories from Greek mythology and other cultures and sharing between cultures for many thousands of years. And I just wanted to share with you all, in terms of content reuse and people picking up others' ideas. I wanted to share an early video example. This is actually a parody example, but it's to give you, I want to give you a range of the types of fair use there are out there. And this is a parody example, but it's also an older example from 1977. This is called Hardware Wars, and it is a parody of Star Wars. Well, I think you'll be familiar with what it's a parody of. Let's see.
Venerable member of the Red-Eye Knights. Princess Android, interstellar damsel in distress. Ham Salad, ace mercenary pilot and intergalactic wise guy. Darth Nader, villain. C, incredible celestial battles, ablaze with death-dealing weaponry.
Okay. All right, so what has changed since 1977's Hardware Wars? What kind of things have changed?
The internet.
Sure, the internet. So which the internet allows what?
Everybody to see everything.
To see everything. So distribution, right? It's lowered that bar for distribution. And then also, what else has changed? I mean, so the distribution is, the cost is much, much cheaper. Maybe not zero, but very close. Most everything is copied? Okay, okay. Gotcha, yeah.
Rights of celebrities to protect their image was greatly expanded.
Oh, that's true. That's true. Over the years, the right. He's talking about the rights of publicity there, but in terms of the creation and sharing of this, I mean, the other thing that's probably changed is just the cost to do something like this, right? So distribution-wise, on the distribution side, what would you have done maybe 30 years ago if you created, what would you have done in 1977 if you created this? How would you have share it with other people? What's that? Maybe some cable access, maybe some kind of film festival, maybe you just cut some VHS tapes or even beta, I guess, at that time and share those beta tapes around at swap meets or something. It's not as easy. The distribution is much harder. Production, believe this or not, I mean, apparently that took over $10,000 to produce. Pretty cool for the time, but I mean, it probably would be fairly easy and probably quite a bit cheaper today as well. My point here is that it's much, much easier. The barriers have been lowered in terms of the production costs, and the barriers have been lowered in terms of distribution costs. So what it means is there's just so much more content out there that is reusing things in various ways, sometimes legally and sometimes not. And so we're going to be kind of parsing through that. And so to give you another example of kind of modern reuse of content, this is a kind of a remix video, which you might call a mashup, by an artist called DJ Earworm. And this artist basically takes the pop songs of the last year and videos and turns them sort of into something, something different. So let me give an example of what he's doing. Okay, so the idea there is you've got, as mentioned, this is a work that is entirely made up of existing works, and it seems very seamless. If you didn't know a lot of the songs, it might seem like it's so seamless that it almost seems like one song, but it's many, many, many songs, many, many videos, and so there's a question there. I'm not saying that it is absolutely guaranteed going to win in a courtroom or not. It's hard to say. Fair use is going to be difficult, as we'll find out today, to have bright line rules about. But it's one of those new kind of examples where it is very easy, as it was mentioned, to cut and paste. And that questions come up of, is this something new? Is it something we should allow, or is it something that we should restrict? Well, and it's probably something further away from parody here. And I show those two as a kind of a juxtaposition. The other example, the Hardware Wars, was clearly kind of a parody of Star Wars. This is, I think, not a parody. This is something different, and it's. What's that?
You can do parody.
Right, parody is pretty well protected in the law, and we'll talk about that when we get into depth and fair use. But as far as this is something different. It's more of a mashup, a remix. And so it's not quite a parody. I don't think.
I sort of have two questions. They're probably not related, but my first question is, in this video, how do they get the material to cut like the clean audio so they can mix it all in? Because that seems like that's proprietary as on some sort of, in some sort of company. And then my second question is related to, I do videos where I'm interviewing for movies or movies basically. And so I interview people and I put it together as an event. This is what happened at this event. And then I lay over usually video of the movie from the trailer. Is that fair use, or is that something completely different? Because it's kind of like marketing for their film and saying they're talking about the movie or the trailer, so I'm using examples from that movie.
Yeah, and those are, so he gave a specific example of when he's reusing footage and having some commentary. We'll talk about fair use in a moment. It's hard to say, with a quick shot, like yes, definitely, or no, definitely. A lot of times, unfortunately, you got to get that lawyer answer of maybe, and the lawyer has to sort of look at it really carefully and see. But we'll look at a couple different examples in addition to this, and that'll start to tell you when commentary or criticism, it sounds like, those types of uses, whenever you step away from parody, that's when there becomes a lot of detailed questions about, well, is this the kind of commentary or criticism that we're gonna, that should be allowed or not? And I'll develop that a little bit more as we move through. But before we get there, I want to just give you all the basics of copyright law and why copyright law is even important to you. And by the way, feel free. It looks like there's some wonderful food over there. If you want to jump up and get some food at some point, feel free to do so. But so why copyright law is important? Number one, it's what protects your creative work from being taken and reused without your permission. So it's important to protecting your creative work, number one. On the other side, especially as documentary filmmakers, where you want to use images, where you want to reuse videos, where you want to reuse a lot of different types of material, music, etc., copyright law can be a challenge because it's what protects all those works of others that we want to reuse in our film, particularly our documentary and nonfiction films. So, if you want to use something as an input for your work that you didn't create, and it's some kind of creative work, the chances are it's probably protected by copyright law. So understanding a bit about it and understanding when you can maybe make choices, making good choices for yourself, but then also understanding when it might be worth talking to an attorney is what we're here to focus on. And just in general, copyright law, I think, reminds us that somebody earlier said everything's a copy. There's actually a whole video series on the internet that I'd encourage you to check out called Everything is Remix. And it's just a kind of a rundown of the idea of creativity in and of itself being a series of outputs. There's the things that are created today, but it's important to note also that the things that are created today are inputs for the next generation of creativity. And so copyright law is all about that balance in terms of how do we get works produced and how do we incentivize people to create, but then also how do we not sort of burden that next generation of creators as well. So copyright law, what does it give you as the creator? As the creator, you are, for life plus 70 years, from the moment you create that work, the only person in the world that can reproduce, right, make copies of your work. You're the only person in the world that can distribute the work. And that doesn't just mean for sale, that means, sharing copies, physical copies, or, through something like a file sharing network or through the internet. So you're the only person in the world that can reproduce and copy the film, only person who can distribute the film. You're also the only person in the world that can make derivative works of the film. So as an example, making a film from a book, right? So J.K. Rowling is the only person in the world that can authorize Harry Potter 22 or whatever the number is that they're on right now. She's the only person in the world that can authorize the making of that movie or the authorized making of scripts from her books. So a movie based on a book is a derivative work. So derivative works are protected. Also, when you create a video, when you create a film, but also when you create any creative work, you're the only person who can perform or display that work. So if you write a play, then you would be the only person who could allow performances of that play. And some of the basic things, the basic idea of copyright I have here, I say, if it's an expression, not an idea, it's protected. This is a really fascinating point for documentary film. So how many documentaries about the Beatles are there, right? There are a lot of documentaries about the Beatles. And the reason you can have hundreds of documentaries about the Beatles is because just making a documentary about a subject is just the idea. The idea of making a documentary about the Beatles, or the idea about making a documentary about what happened in Ferguson, Missouri this summer. Those are ideas. What happens is that it's very different once that expression has been made, and once you're taking specific expression, copying a video segment, taking a particular image, taking a particular interview you really like from, say, another documentary or from another source, that's when you run into trouble. So to boil that down even further, a really basic example would be a newspaper article. So if I wanted to write an article and say, Governor Jerry Brown came to speak in Glendale on X date, and he was speaking about such and such topics, so I could write, let's say that, I saw an article out there about Governor Brown speaking, and I want to write my own article. Well, the basic facts that were already existing in that newspaper article I saw, right, that it was Governor Brown, that he spoke at X location, that he spoke maybe about this topic or that topic. The basic facts are, what day he spoke on. Those are all public domain. And that's kind of easy to understand. How could somebody write one article and then foreclose anybody else writing articles about it? That would be, that would have a very disturbing impact on freedom of speech if we couldn't all speak about that event where, say, the governor spoke. However, the problem where I would get into trouble is if instead of just saying, I saw that he had spoken there, I wanted to write my own article about that, but instead of just using those basic facts and writing then my own opinion about what happened, if I copied a 7-paragraph article verbatim or with tiny changes and passed it off as my own, that is copying the expression. That is copying copyrightable material. You see? So you have the right to reuse and to use ideas. It's very, very important for us to have that right, but you don't have the right to take folks' specific expression of those ideas. And examples of protected works, well, you've got books, movies, scripts, songs, comic books, musical compositions, photographs. Those are some of the traditional media protected by copyright, and that is drastically expanded. When the United States started back in 1789, it was books, maps, and charts. That's what was protected. So you can see that copyright law has been affected by technology, really, right? So as photography developed and everything, all these types of works were added to the list. Well, that just has been expanded into the digital world. So blogs, podcasts, digital recordings, whether video or audio, they all also have copyright protection, just like some of these traditional media would have. So creative expression is what's protected. Probably very helpful to understand what copyright protects is to talk about what it doesn't protect. First, I said it doesn't protect ideas, right? Ideas and facts are not protected. It also doesn't protect titles and names. Trademark might protect titles and names, but copyright does not. So titles, names, even short phrases or slogans, not protected by copyright. Maybe by trademark, but not copyright law. Federal government works. This is really important for documentarians. Federal government works are not protected. They are public domain, period. There is no copyright protection. This is really important. I mean, if you want to do a film about war propaganda, there's tons of that available. You can find a lot of that available. The Internet Archive has a lot of films, not just about war propaganda, but also about other kinds of films. The federal government, over many decades, made many different kinds of films. Many different of the departments made various kinds of films that you can access. Archive.org has a lot of that material. And so if you see something, written material on the State Department website, things like that, you generally, if it's created by a federal agency, right, or created by the federal government, it's in the public domain. That tends to, there's a little bit of a wrinkle to that, and I'll just say the one little wrinkle is because we contract so much out from our government, there are a lot of folks who, they bring in maybe an illustrator or something, and they don't necessarily get all the rights, so you do have to watch just in case there's something where it's an external artist that they hired but didn't actually get the rights. But mostly things that you're seeing from the federal government, if produced by federal employee, are in the public domain and you can freely use them. Oh, sure. Well, I mean, it can get into, and it might not have just been that they were hired, the government might have licensed the image or something from them. And so all I'm saying is that just to keep an eye out in that I didn't want to, it's mostly that you can use federal government works, but it's just to be aware that there might be situations where you might not be able to.
Websites like Free Sound or Flickr,
Right.
where people have put up their work, but they say you can use this if you attribute it to me.
Right.
Is that fair game? If you attribute it to them?
Right, well actually, and at the end today I was going to talk a little bit about Creative Commons, but generally yes. I mean, and unfortunately when you have, one of the issues with the internet though is certainly from time to time you will get people errantly, having their stuff posted without their permission, and someone says, oh, it's under a Creative Commons license or it's under an open license. But for the most part, if you see something, on Flickr particularly has hundreds of millions of photos that are under Creative Commons license, and those photos, there are 6 different types of licenses, but generally the key issue is that you attribute them correctly. But I would say that Flickr does allow you to use any of the 6 Creative Commons licenses. So when it says just attribute me, you may look closer because some of those also require other restrictions, like don't use it.
Go over those later.
Yes, like don't use it commercially and things like that.
And, never mind, I'll wait till later.
Oh, okay, thanks. And I'll talk about that, but most of the time it's reasonable to the medium. And I think in a documentary film and in video, I think it's reasonable to do it in the credits. Okay. And a lot of times folks will do it, if people are really trying to do it in good faith, a lot of times people will put it in the credits, and then they'll even, in a maybe if it's on YouTube or some kind of online venue, they might put it in the kind of comment section or the description of the video, some kind of credit as well. Sure.
Well, so on the short phrases and slogans, they can't be copyrighted. I guess you said they could be trademarked?
Could be. They could be trademarked, yes.
I had an example a while back. I think it was a car commercial, a truck commercial that had a very short slogan, and it had a trademark. But it didn't make sense because it's something that was so natural in conversation that you could just use. It's how am I barred from using a short, easily accessible? For example, one idea that comes to me is the Live Strong bracelets. Well, if I want to tell someone if my advice is for them to live strong, why couldn't I use something like Live Strong? I mean, that seems ridiculous. How can they own that phrase?
Right. And the thing is with trademarks are very different from copyright. Copyright is about protecting that creative expression. Trademark is really just about knowing that when you buy a Coca-Cola or when you go to when you go to a Starbucks, that the source of your goods is a particular source. So, you know, to the extent that you're not implying that there's some sort of endorsement or sponsorship, then there is some ability to talk about, you think about a show like The Daily Show or something like that, right? Where they'll maybe talk about a company and put up the logo. You're allowed to, and newspapers will talk about companies, like you're allowed to use trademarks in certain what are called nominative situations, where you're just referring to the trademark. And so, you know, well, trademark is kind of far-reaching because trademark is, as long as you use it on a good, it's forever. You know, copyright's pretty long. It's life plus 70 years, which means if my 7-month-old son, you know, creates something today, hopefully lives a nice long life, and then it'll be 150, 160 years from now that thing goes in the public domain. Trademark is forever, but at the same time, even though trademark is forever, there are some exceptions to that. And that's something, you know, we do at New Media Rights, is help you understand whether your use of a trademark is okay or not. But right now we're talking about copyright, and the last thing about things that are not copyrighted, this is really important. Anything that's in the public domain is not protected by copyright. Now, I just told you that federal government works are fair game. They're in the public domain. But also anything before 1923 is fair game. So because of the Copyright Extension Act in the late 1990s, there's nothing going into the public domain until 2018. And hopefully we won't see another extension, but we'll find out. Oh, sure, go ahead.
1920, any media from before 1923.
That's right.
You can use anything.
That's right.
In any way you want.
Yeah, basically there's no attribution requirement. Even in Europe, they have they have stronger what are called moral rights, where you sort of have to let people know if it was originally created by a certain artist. In the United States, if it's before 1923, it's fair game. And, photographs, things like that. And you know, Flickr they've worked with the National Archive to put up a lot of photos that are prior to 1923. They also have a lot of federal government photos that are amazing from the 30s. From during the Depression era and the Civilian Conservation Corps. There were actually people employed as photographers and went around the country documenting life. So there's a lot of media available before 1923. Not a lot of video media, but there is, you know, some. And there are works that are after 1923 that are public domain. However, it gets more complicated. And it's just, you know, if you have something that you believe to be in the public domain that's after 1923, I think it's a good idea to speak to somebody, some kind of an expert about that, and to find out if it really is or not. It's very difficult because of the way the records are kept at the Copyright Office, especially things between 1923 and 1978 or so, can be very difficult because there were requirements that you had to put Circle C, 1972, you had to put these things on your work to get protection, but it's very difficult to kind of prove whether something was public domain or not. So during those years, you know, there could be something in the public domain, but you might want to talk to an expert. What does this all mean, though, for you as a filmmaker and your own work? Well, it means that you have protection over any original videos that you create, any scripts that you write. They're protected by copyright law, which gives you a pretty good amount of protection, as we saw. But you know, and you don't have to actually, in this day and age, ever since some of the reforms were made in the 70s and 80s, you actually don't need to put the Circle C 1988, you actually don't necessarily need to register the work to get basic copyright protection. As soon as if you're filming and it's fixed on a medium, you know, flash medium or something like that, as soon as it's what's called fixed in a tangible medium, that just means saved. As soon as it's saved and fixed, that's protected. But here's the thing. It's really, really helpful if you register with the Copyright Office, and it's not that expensive. You can do it online. It costs, they've just changed some of the fees, but you can still do a single work, I think, for $35 in most cases. So once you've got that film ready to go, before you publish, I do recommend registering that with the Copyright Office. And the reason you register that is that if it's used without your permission, two things are available to you. Number one, attorney's fees. And to be completely frank, having done this over the years, I do mostly preventative transactional law, which means I'm mostly working with people trying to avoid the need for lawyers. But I've seen when it gets to the point of needing attorneys, and I'll tell you right away, attorneys won't take the case if the thing was not registered. If the work wasn't registered before it was copied, they won't take your case. And that's really important for independent creators. It's not always easy to make a choice, especially if you're a YouTube channel creator. I gotta tell you, it's not an easy choice for a YouTube channel creator to register every video. That gets expensive, especially if you're producing multiple videos a week or even a video every week. It can get pricey. So you can do that if you're somebody who is producing a lot of videos. What I would say is, watch it closely for those videos you think are going to be very popular, or for those videos you see quickly gaining popularity, go ahead and register them. Sure. There are some ways to register collections. Honestly, the Copyright Office is much more friendly to the kind of classic examples of periodicals and newspapers and physical print media collections and those types of things. There are ways to do that, but there are certain requirements you have to meet to be able to register like that. So to be able to register as a group, as a collection, to make it cheaper. And unfortunately, they need to do some reforming of that too, because the other people that it hurts quite a bit is bloggers. I mean, bloggers, you're not going to register every blog post you're going to write, but they make it very difficult for bloggers to actually register as a collection for your website. So there is some reform that needs to happen on that front. In terms of, so we're talking about what copyright means for you, the filmmaker, in your work. Well, it protects your work. You should register the work. And then when you upload it to YouTube and other social media sites, you may already know this, but just so that you know, you're giving them a non-exclusive license. And they don't have ownership. They don't have an exclusive license. You're not doing what's called an assignment. They don't own your work. So if you upload a video to YouTube or to Facebook, those social media services, they don't own your work. You have the right then to post on any other service that you want. It's a non-exclusive license, which means Facebook and YouTube can show your work, but you have the right, you retain ownership. So, and that is a good example of what a license is, period. And so remember, I told you could do 5 things as the copyright owner. You could copy it. You're the only person in the world that can copy your work, distribute your work, make derivatives, and then perform and display. Well, a license is just simply letting someone else do that. That's all a license is. It's saying, oh, well, you can distribute my work, distributor, or you can make copies of my work, or you can make a sequel to my work. You can make a derivative of that work. And so licensing is just licensing out those basic rights that we talked about. So that's how copyright affects you and your work. But what does it mean for you and the work of others? Well, it means that you don't have protection to audio or video, it means that you don't have the rights to use audio or video or images from another source, generally without permission. So you either need one of 3 things, and this is really good for you, a good takeaway. Anytime that you want to reuse, it doesn't matter whether you're doing fictional, non-fictional, YouTube, feature length, you've got to have one of these boxes checked to reuse a work. You either need direct permission in the form of a license, or the work needs to be in the public domain, which I told you is a limited set of works before 1923 and federal government works, Or the third option is fair use. And fair use is a situation where you actually are permitted to reuse somebody else's work without permission. So there's the basic rights of the copyright holder we talked about, the right to copy, the right to make adaptations, making a film from a book or a script, for instance, distributing copies of your film. You're the only person that can do that, and performing and displaying your film. So one thing to think about, though, especially if you're trying to reuse somebody else's work, is who actually owns the work. And this can be kind of tricky. I mean, if it's an independent creator who retained their rights, that can be fairly simple. As I said, life plus 70 years. So it could be the author-creator that owns it. If, unfortunately, the author-creator has passed away, the heirs might own it. The heirs might own that work that you want to reuse. It can get a little more complicated, however, if the work was a joint work. And this can sometimes come up when you're shooting a film and there are different people playing different roles, and you haven't really gotten any of those expectations set up front like we talked about through a contract. You know, if 2, 3, 4 people are working on a creative work, whether that's music or a film or whatnot, sometimes they can have joint rights in the work. And so, you know, that can create another situation where, you know, there are multiple folks that actually have the right to license out that work. And probably the most important thing to remember, and this is particularly true with music, is that the owner, the copyright owner, may not be the actual artist. You know, it could be the recording studio, and that's very true with musicians. So, you know, it means if you want to get rights to the film, or sorry, to the music to use in your film, just because you know somebody in the band doesn't necessarily mean that them giving you a thumbs up or them sending you an email or something saying, yeah, go ahead, use that song, no problem. It might not be the band member that actually owns the work, right? So you got to go ahead and actually get permission from the recording company. So a couple things about that, couple notes about that. Only the copyright owner can claim infringement. Online, there happens to be an unfortunate amount of bullying that takes place where someone says, oh, you know, this is copyright infringement. You shouldn't be reusing this work this way. And I just want to tell you all right now that third-party threats, if it's not the copyright owner saying that it's copyright infringement, they're unenforceable. You don't have to pay them any credence, although, you know, sometimes people can be persistent about that, and we're happy to help you with that situation at New Media Rights. And it's very important to remember that the owner may not be who you think, right? So I explained that in the recording situation, but I also have a documentary film example. There's a famous case of somebody who was doing a documentary about the San Francisco Symphony, and they were actually doing a documentary about the crew that's behind the scenes at the symphony. And in that documentary, they happened to have caught a couple seconds of Simpsons footage, and it was this whole scenario where the documentary filmmaker, well, they went to Matt Groening, one of the creators of The Simpsons, and he said, oh, that sounds fine, no problem. I mean, there's just some Simpsons in the corner of a shot for 4 or 5 seconds, not a big deal. But you might want to talk to Searchlight. So he goes over to Searchlight, and then Searchlight says, well, that's probably okay, but actually you really should talk to Fox, because they're the ones that really own it. And so they went to Fox, and it was $10,000 a second was what was the quoted license price. And the point is that you might think you've talked to the owner, but there might, you just really got to figure out who actually owns that clip, owns the rights to that work. Now, what's that? I think they, what's that? Yeah, I think my understanding is that they changed, it's exactly what was just said, is that they did change the scene. Thanks for that they actually changed the scene and dropped the clip.
They replaced the clip on the TV with a different one.
There you go, yeah.
I remember reading about this. I did a Burden documentary, however, that was the quote about it. It said I couldn't afford the rights to the actual clip.
Right, and so it was stated that he might have replaced the film, the actual video of The Simpsons with some other kind of clip, which is probably pretty disturbing to folks who are documentarians who are actually trying to document the real situation, right? So there you go. It's a good to kind of know your rights and know the situation. And you have to make tough choices. You know, sometimes, I'm not necessarily saying that it was the wrong choice either. I mean, it can be very, very difficult choice to make. Sometimes even when you're in the right on fair use. Sometimes when you're even in the right, you just have, you know, you also have to make that choice of, is it something that you're prepared to actually battle about? Sure. Yes. Yes, just about to get there, actually. So when we're talking about, I was just going to talk about licensing and then fair use. So licensing and fair use, we talked about public domain, but licensing, so let's say you want to get a license. You actually want to get permission. Just a few notes about getting a license. You've got to negotiate generally you need to negotiate with the copyright holder directly. However, there is a lot of openly licensed music, as was already, and photos, which was already mentioned here. There's a number of photos on, things like Flickr, and then there's also music-wise. There's a site actually called Incompetech, which is a heavily used on YouTube background music site, and he does really granular, really neat. Different types of music. So you could say, I want, happy, bright electronic music or something like this. And you can be very, very particular about the type of music you like. And he has a very nice system and has made quite a business out of it by saying you can either use my work and attribute me, or you can pay me $35. That's Incompetech.com. I've got it up there on the screen right now. So there's a lot of sources of openly licensed music, and that's where people say to you, look, you can reuse my thing, and here are the conditions, go ahead. You don't have to negotiate with me. But in a lot of situations, you need to go directly to the copyright holder and negotiate with them. So if you're doing that, particularly if you're doing it for music, for your documentary, and I've worked with a lot of music-related documentaries. So music can be kind of complicated, which is why I bring it up. You know, it's a tougher one. You need two things generally with music. I mean, music is complicated because there are two rights. There's the composition right? There's there's the composition of the music, and then there's the actual the sound recording of the music. Those are two rights in the same work. So music can be fairly complicated under copyright, and what it means is you need to get, when you're syncing, when you're putting that music in your documentary film or in your film, you need to get a license to synchronize the music from the publisher with your video, but you also need what's called a master use license from the recording company. So it's just to let you know there might be multiple people you have to approach. Licensing fees can vary tremendously, but I do have some good news there. You know, I've worked with a lot of documentary filmmakers over the years, who have been able to sometimes who are doing it as a passion project or some kind of educational project. And if you're persistent, you really can they do really have different rates. The first rate they're always going to quote you is the rate they're going to quote the largest studio for that music. But you've got to come back and you've got to make your case that it really on two fronts. A, I'm a sophisticated filmmaker and I know how to ask you correctly for this music. But at the same time, I'm doing this for various educational reasons, and I don't have a huge budget, and you should really give me a more reasonable fee for this reason. So two things I have to say is be persistent and make sure to get a reasonable rate, and then also get the rights that you need. This can sometimes be a big problem. Even if a record company is willing to give you a reduced license, they may not give you the rights that you need. So if you want to distribute DVDs, well, you need to have the right to distribute DVDs. If you want to stream, you have to have the right to stream. If you want digital downloads or the right to show at film festivals, you need to get that, right? And then also, just as a side note, if you wanted to get rights to do a soundtrack, say for a music documentary, that's separate. Those are separate rights that you get. I know this is a lot on one slide. I'll share these slides so you can look at them closer. But the point is to be very specific. Be specific with them and just have a nice, when you approach them, it's great to have these basics there. Here's what the film's about. Here's the basic budget of the film. And here's exactly how I want to use the music. And tell them, I want to use 37 seconds of this during the open credits. I want to use 25 seconds of this song at this point in the film. And then I want to run this song over the closing credits. The more you give them, the more specificity you give them, the quicker they can get back to you and get you, and the more likely they are to deal with you. Because if you just come to them and just say, well, I kind of need a license for my film, they're already super busy doing these license deals, and they're used to people coming to them with very specific requests. So they might even be, they're already going to be, in the most part, especially a larger recording company, it can take some time to work with those folks. So the more specific you are, and the more you give them exactly what you want, the better outcome you're going to get. So tell them where your film's going to be screened. If it's a student film being solely to be screened in an educational environment, although that's tough to imagine these days. I mean, it seems like everyone would upload it somewhere. So, but if it is limited, tell them that it's limited in terms of how it'll be released. And sometimes you can leave options for later. So you might pay a reduced fee today, but if the film is very successful, you might have an option in there where it's like, okay, I can pay $5,000 more and I am able to have all the streaming rights or something like that, right? So it depends on what you want, but think about what you want. Tell them exactly how you want it to use it, want to use it in the film, and then how you want to distribute your film, and then you'll get the license that you need. And you can, and also if you have any issues with that, that's the kind of thing that an attorney can be helpful to make sure that you actually get what you need. Because I have seen a few films caught up and held back because they didn't get that right. And the problem comes when you didn't have a good fair use argument, you needed a license, you didn't get it, and then your film gets from the point of unknown film to suddenly being interesting, at least even to a niche community. And as soon as it becomes interesting to some audience, a lot of people over assume the value of that film. Then I've seen a lot of people say, well, that must be making a lot of money. I mean, it has 10,000 Facebook followers and it seems to, be appearing on Netflix or something like that. That doesn't necessarily mean that the filmmaker is making a bunch of money off of it, but even the perception they are can then make your negotiation harder later on. So I'm saying taking care of this stuff early on can save you a lot of trouble later on. So if it's public domain, you can use it. If it's licensed, once you get a specific license from somebody, you can use it in the way that it's delineated in that license. But then there's fair use, and fair use is all about your ability, as we said, to reuse without permission. Does anybody recognize this image that I have up there in the bottom corner? Yeah, it's Jay-Z in the front, and then it's the Beatles in the back. It's the Grey Album. And the Grey Album was by a musician called DJ Danger Mouse, and it was from 2004, and it was actually 2004's Album of the Year. Another sort of mashup album in a situation where the Beatles music was sort of spliced up, used as various background for the Jay-Z lyrics, which actually were licensed, and the Beatles stuff was not licensed. And there was a big argument about this. You can still download the album for free online, but it's never been sold because of the dispute that happened. They actually ended up, EMI, which had the issue with DJ Danger Mouse, decided to drop the issue once one of their artists actually wanted him, an artist called a band called the Gorillaz wanted him to master an album of theirs, and so EMI decided to not press the issue anymore. But it's one of those questions where the album, the Beatles album, wasn't used in big chunks. They were actually used in tiny, tiny segments, almost as an artist's palette, where like sort of various semi-seconds or a second would be used as almost like a palette to make the sound. And a painstaking process, actually, and something where many times during the album you might not even necessarily recognize the original backing track. But it raises this issue of fair use, and it actually underscores my first point about fair use, which is that it is very difficult to predict. it is difficult to predict. It's not, there's only I think a small amount of situations where you can say, hey, this is absolute, it's very hard to say it's absolutely fair use. I think there's a lot of things you could say, okay, this is a very strong fair use argument, but there's a lot of gray areas, there's a lot of gray areas in fair use. And what it is for certain reasons, criticism, commentary, news reporting, teaching, you can't, scholarship, research, and in documentary film, we're talking a lot about criticism. We're talking a lot about commentary, right? That's what that's what a lot of good documentary films are all about. You're allowed to reuse works without permission, right? If you're criticizing, commentarying, news reporting, teaching is not an infringement of copyright. Unfortunately, it's not that easy. Just making copies of something and using them, say it says teaching here, right? That does not mean the teachers can just make any kind of copies they want and use them in the classroom. Unfortunately, there were a lot of cases in the late 1990s where copy shops like Kinko's and universities got in big trouble for teachers making and professors making course packets without permission. But in terms of fair use, I've got two examples that lead us, that help us get oriented with fair use. One is this Buffy versus Edward. This is another remix video. This is a criticism of the Buffy, of the Twilight actually series, and the Edward character as sort of a lurking kind of stalker-like character that's glorified in these stories by juxtapositioning him against Buffy the Vampire Slayer. So this is by a remix artist called Jonathan McIntosh, and we'll watch this example and get an idea of what fair use is all about.
Hello? I'm Edward Cullen.
So, spill. What's that all about? Nothing serious, I think. It looked like more than that to me. I'm googly-eyed. Survey says, vampire.
I'm sorry, I'm just trying to figure you out. You're very difficult.
I'm the Slayer.
Um,
Slayer. Chosen one. Look up.
Okay, so that's Buffy versus Edward. You can watch some of Jonathan's remixes online, but you can see in that case we're talking about, not sort of a. Again, this gives you the range of uses. We saw a parody earlier. Here we see sort of a commentary criticism by juxtapositioning the two works. It's not necessarily someone talking over the work and talking about the work. It's somebody sort of criticizing it by juxtapositioning the work. And then you have an example that's even really fits what we're talking about today, which is documentary film. And I have a clip here, a trailer actually, from one of our clients. So Jonathan McIntosh was actually one of our clients at New Media Rights, and we've helped him respond. He's had dozens of videos actually identified, mostly by large media companies, and taken down for copyright infringement, but we've helped him kind of fight back and be able to get those videos back up. And in fact, he actually testified has testified at Copyright Office hearings before about this film. And if there's one video that I feel most confident about it being fair use, I actually feel quite confident about Jonathan's video being fair use, because the Copyright Office in 2012 in fact identified it as a great example of fair use when they issued a rule that they were issuing after he testified up here in LA. So here we've got an example though from documentary film, and I think fulfills, this is Valentino's Ghost. This is a client of ours from right here in LA, Michael Singh, who made this wonderful film. Again, this is a definition of the folks that we just, love to work with. This is oh, sure.
It's fair use because he changed the meaning or whatever. Is that what you're saying?
Right, and we're going to talk about sort of transformation and why Jonathan's and why Valentino's Ghost, have some good arguments as to why what they're doing is fair use. And yes, exactly, particularly with regards to Twilight, it was all about, criticizing and sort of putting the Twilight character in a different light by juxtapositioning him against this sort of stronger female lead character. And it was a commentary about the Twilight series. So here is Valentino's Ghost. This is all about, this film is all about the way that folks from the Middle East have been represented over the last 100 years in popular media. And you can I'll give you just a bit of the trailer here so you get a sense of what this film was all about.
Where do these images come from? What is the relationship between these images and American foreign policy?
America's love affair with Arabia reached a frenzy with The Shame, starring Rudolph Valentino.
Because it was represented as a place where there was a lot of romance and excitement.
What ended America's love affair with Arabia was actual contact. The British Empire invaded Egypt and Palestine. In the media, the Arabs, not the British, were the attackers.
The mainstream media presents a rich diet of pictures of Palestinians blowing up targets in Israel.
I was watching the news, and Walter Cronkite said Jerusalem has been liberated. It had been liberated from whom?
What you do is you change and diminish the language of conflict. The wall becomes the fence or the barrier. The occupied territories becomes disputed territories.
Intelligent coverage of the Iranian hostage crisis dwarfed the coverage of the civil rights movement and even Vietnam. It was the obsession of American television news for more than a year.
The United States goes into the country promising democracy, freedom, liberation. These seems very graphic images of what the Americans.
Okay, so what we've got here is an example of a documentary film and how you might reuse images and news coverage and films and popular media like television shows to tell the story that you're trying to tell. And particularly in documentary, if you're trying to cover a particular time period, right, the way that folks from the Middle East were represented over the last 100 years, or the way that homosexuals were portrayed in 1990s popular culture, how do you do that with just original content? I mean, at some point, you need to make the points that you're trying to make, or you actually have to be able to show the thing that you're talking about at some point. And so, when courts review something like Buffy versus Edward or something like Valentino's Ghost, they look at 4 factors, okay? And the 4 factors are the purpose and character of the use that you're making, the nature of the original content that you're using, how much, the amount taken, as well as what is taken from the original work, and then does your use have an effect on the underlying market for the work that you're using? So purpose and character of the use, you look at 2 things. Number 1, is your use, oh sure. Oh, sure, you bet. Oh yeah, we're gonna go, and we're gonna go through each one right now. Oh sure, go ahead.
Number 4, the market effect. Why didn't the critics of Valentino's Ghost argue that we were so ridiculed for what we were doing that the value of the work increased?
Well, I think that you actually get at the question was, why wouldn't, say, folks who, and actually there wasn't a challenge to that film, but I raise it as an example of fair use. Why wouldn't people whose works were reused in that film be able to argue, hey, well, there's so much criticism that it would diminish the value for our works? Well, there's actually a case, and it was a Roy Orbison case, where 2 Live Crew did did a remake of his Pretty Woman song, and it was a parody, and it's called Campbell versus Acuff Rose. It went to the Supreme Court. And in that case, they were speaking about parody, but they were talking about what's called transformative use, which I'm about to mention in just a second. And it's about transforming that original work. And they particularly talk about the fact that even though the Two Live Crew parody was really kind of making fun of the original and kind of criticizing the original, even though it was kind of putting down the original, that actually was a big positive. Why? Because why would the original artist have licensed it in the first? The original artist was even less likely to license it in that situation. So in that situation, there might even be a stronger argument, because the artist would be less likely to license it. So going through the factors here, purpose and character of the use, you look at two things. Number one, is it commercial use or is it non-commercial use? If it's a non-commercial educational use, it's helpful. It is not determinative, though. Just because you're not making money and you're reusing something does not mean that it's necessarily okay. But if you are making money and you're making commercial use of it, it's that much more likely, A, that somebody might practically come after you, and B, it does make the legal argument against you stronger and make it less likely that you can rely on fair use. So you ask yourself first in factor one, is it commercial or is it non-commercial? Second factor of factor one, and really honestly the most important in fair use, is your use transformative? And the 4 videos I've shown you tonight are varying degrees of transformative. And what that means is, does it transform the original work? And think back to my example, or actually let's talk about Michael's example, right? So you have these clips. Let's say of he uses some films for like very short clips of films, right? So if you look at those clips of the film, you ask yourself, is he using it for the original purpose that it was using in the film? Which a lot of times those films they were entertainment films, and people were supposed to pay some money to go to a theater and be entertained. He's using it for the purpose of showing culture, in popular media at that time, what were the representations. And so in that situation, the use is very different than the original purpose, which was, say, to entertain people. Same with the 1990s sitcoms. If I'm using a clip from 1990s sitcom, having characters talk about homosexuals and views on homosexuals from 20, 30 years ago, then if I'm having them do that, I'm not doing it for the original sitcom entertainment purpose. I'm doing it because I want to specifically show, the way that a certain group was portrayed in the media at that time. And so transformation, are you adding something new to the original work? Are you adding something new to the original work? And I have actually something that is maybe not so easily categorizable, but another example of, it's a challenge. This isn't necessarily a case that's happened, and nobody has necessarily proved this video fair use or not fair use, but I raise it as another example of the types of maybe question marks that are asked in this day and age. So this is basically a remix of Alice in Wonderland into something entirely different. Okay, so it's hard to, I can't necessarily say exactly what the purpose is there, but I know it's something pretty far from the original. It's something different than the original Alice in Wonderland. It's something that folks could argue about one way or the other. But my point is that transformation is about adding something new changing the original in some way. And that usually has to be pretty significant, right? That usually has to be pretty significant. On the flip side, what is not transformative? Well, if you just really like a song and you think it sounds great and that it should just be in the background of my video because I think it sounds great, that's not transformative, right? Just because you like a song a lot and you just put it in the back of your video, that's not typically transformative. Transformative typically has to do with, really changing or juxtapositioning or putting that work in a new light. But, oh, sir. Oh, that's the kind of thing we could talk about maybe afterwards, and it is the kind of thing that we would, that we do work on. So it'd be something that we can definitely talk afterwards about that, a specific example, yeah.
Are you familiar with a piece called A Fair Use Tale by a professor of Bucknell University?
A fair use tale?
A fairy, with Y and he matches up Disney's searches.
Oh, I believe I have seen that. So somebody was mentioning of a short film called A Fairy Tale, but with parentheses around the fair use tale. Okay, great. Yeah, there are some examples out there. But that's only one factor. There are actually 4 factors you look at. Transformative tends to be the most important thing, but you also look at things like the nature of the original work. Is it fact or fiction? Well, if it's heavily factual, if it's heavily nonfiction, again, as I told you, you're allowed to borrow facts. You're allowed to borrow facts. When you get into courts, look at, is it sort of highly creative? Is it at the center of what copyright is all about protecting? Or is it something that's on the fringe and really something that's mostly factual and we shouldn't worry about protecting? So, if it's highly creative, it might be more likely to get protection. The more factual, the more nonfiction, the less likely to receive protection. But something that's really important in terms of the nature of the underlying work goes back to a fair use case from the 80s about a Gerald Ford memoir, where somebody took 300 words out of Gerald Ford's 40,000, or actually probably a couple 100,000 word memoir, and it had to do with why he pardoned Nixon and the details around why he had pardoned Nixon. It was the heart of the work, and no offense to President Ford, but it was the thing that people cared about in terms of President Ford's presidency. They wanted to know what was going on with that. Somebody took those 300 words, they published them, they had been unpublished up to that point, and that court was very reticent to allow that use when the work was unpublished. So if you're using something that has not been published yet, just be aware that courts are a lot more protective of unpublished works. So you look at the nature of the underlying work. You also look at the amount taken, and this isn't as simple as and I just want to say there's no bright line rule. So you might have heard things like 5% or 10%, or can't you just use some percentage? No, there's no bright line rule, and it's not just about quantity, right? There's been many fair use cases where you take the whole thing and it's okay. But also there's been fair use cases often in music where you take a few note, even a few note sort of riff can be copyright infringement. So it's not always about the quantity. You look at how much was taken, yes. You also look at how much of when you took that, how much of the work that was created was made up of what you took. And then you also look at, did you take the heart of the work? And this happens to be where people argue quite a bit. Was this the heart of the work or not? In music, it tends to be arguing over, you took the riff, you took that really heart of the song, and you shouldn't be able to do that. This is why those music sampling cases from the early 1990s really heavily restricted music sampling. And so, how much of the original work did you take? If you're taking, you really, and the rule of thumb in documentary film is to just take so much as you need to make your point. That is a golden, that is the rule of thumb. Only take as much as you need to make your point. As soon as you're using more than you need and you're just using it aesthetically because you think that it looks neat or you think that it sounds cool, that's where you get into trouble. So if you're trying to make a point in your film, make the point, use just as much as you need to make it, and move on, right? It's when you have music, let's say, and this would be a great example for, you're doing a jazz documentary, and you have to show, certain characteristics of playing from, let's say, the 1930s, and trumpeters, certain skills that were developed during those years and methods and things like that. And so it's one thing to take, a couple of seconds or a short clip to say like, oh, people started playing in the upper register and they started hitting high C's and no one had hit high C's or something like this before. And to maybe take a few seconds to do that. But when you let that song linger on for a minute, and then it transitions to your next scene and it just sounded kind of nice to you, and so you just let it go, and you're not specifically commenting on that song in any way, then it's going to be hard to argue that you have any right to use that. Yeah.
And it's very subjective.
Right.
Okay, well, but my point really was this.
It does. It does get into some gray area, and that's why I try to, I think it's good to know some of these basics, and it also tells you that, especially if you're making a film that's heavily reliant on fair use, it's worth talking to some folks. And the good news for you is that over the years, there's new media rights, but there are other, legal clinics at law schools and things that do provide services as well. And there's plenty of lawyers certainly in the LA area. Certainly you guys have plenty of firms that do that. Donaldson and Califf is really known for doing that quite a bit. And so you have resources, and it's just something, and it's something to have even if it's a gray area, it's something to make some good choices about early, rather than just shoveling it under the rug and saying, well, maybe I'll deal with that down the line. What happens is you get a film, and I've worked with films that, they're bootstrapped, but then a year or two goes by and all of a sudden they're in the final group of contenders for being nominated for the Oscars, and then them having themselves together at that point for distributors or for whatever is so important. And so making choices, saying we're going to go with fair use or we're not going to go with fair use, and making conscious choices about that, and understanding maybe I should get insurance for this or not, because maybe even if you're in a gray area, if you had an attorney kind of back you up, you might be able to get insurance coverage that help you. So yeah. Okay, so amount taken, and the very last factor is market effect. Is your new film a direct substitute for the original? So you create this film, you create this video. A good example actually to think about would be to think of, videos on YouTube, right? If your video on YouTube, you've simply used as a background an entire song or a huge segment of a song, and it's just and you haven't done anything or transformed that song in any way, well, if people can just go to your video, and I know a lot of people do go to videos on YouTube to listen to songs, right? That's something that some people do. They go to the video to listen to the song. Well, if you're just a source for that work, then that tends to go against fair use. If people can go and simply buy, download, view that original content from you as opposed to the original rights holder, then that can be a problem. However, this factor gets muted and becomes a little bit less important the more transformative the work is. So the more transformative the use of the work is, the less critical the market effect is. Yes?
Well, an example just popped into my mind. I used to watch Good Morning America, and they have an exclusive interview with some celebrity or some sort of politician, and it's like this blockbuster interview. And so later on in the evening, Inside Edition, for example, I don't know if anyone here works at Inside Edition, but let's say they do a story, they lead their show with that interview because it was exclusive. So they treat it as though it's a story. Here's what happened, here's what they said, here's what here's what the interview asked and how they answered and the reaction.
Right.
So they basically just repackage that same content for their own show.
Right.
How does that allow for one? And then let's say Inside Edition's new package of that interview, they own that now. Do they own that?
Right. So, okay. The question, so there's two questions there that are really good. Question was for something like, let's say, an Inside Edition or a television program that's borrowing from another, an interview or some other program and trying to talk about it. How does that work? Well, I can't guarantee that they don't. I can't guarantee actually that they don't get licenses or not. I don't really know how their process works at Inside Edition. Some stuff they might get licensed for, some stuff they might not. I find more and more that it seems like the big guys, the big media companies get licenses from each other. You know, like like evening news programs get licenses from all, let's say they're putting up sports. Well, they got all the licenses for the sports. But increasingly you'll see YouTube videos and things pop up on news broadcasts, and the licenses and permissions are a little bit more shady in those.
For example, Media they just take from everywhere.
Media you said?
Mediaite.
Mediaite, okay. Yeah, and so that was the first part of your question, and the second part of your question was.
I guess you answered it by saying if it's done through licensing, I guess it does it become their original work?
Right, and so if it actually is fair use and it's found to be fair use, then yes, it's a protectable work. So you can, for instance, if he wanted to, although he's the kind that, well, for instance, right, Michael's a great, Michael Singh in that Valentino's Ghost, the film about the representations of people from the Middle East from the last 100 years. So in the media, he has original footage and original interviews, but he also has reused footage. And that combination is such that it has a good fair use argument. And yes, he has rights to his film. And certainly if somebody took and borrowed parts of his film, and he could protect that, So yes, you do have some rights even when you use, as long as it's got a good fair use argument. And so if you step back through some of the films that we saw, or some of the videos that we saw, particularly I showed you the Buffy versus Edward, how is, in terms of the Twilight series, right? It's about a 5-minute video. It's a mix of Buffy versus Edward as well as Twilight video from the film. So you're talking about probably 2 to 2.5 minutes of the Twilight film that was kind of retooled to fit into this video versus, how long was the film? Probably an hour and a half. So you look at the amount, were the reuses in Valentino's Ghost, in Buffy versus Edward, were those the kind of reuses that affect the market for the original or not? And you sort of ask yourself, you have to ask yourself that question. And I think they were pretty reasonable uses. The amount and substantiality you're talking about was not very much. And in terms of the market, there's not really a big market effect there at all. So a couple last notes about fair use, just attributing, just saying, hey, I don't actually own this, this other person owns it, is not an excuse and doesn't sort of allow you to reuse something in fair use. So just attributing isn't, and you see that a lot on YouTube, but it's not necessarily, it doesn't necessarily mean that it's a fair use. Just putting an attribution, just putting a disclaimer, is not, or an attribution is not a legal shield. So, just saying that you're using something under fair use doesn't necessarily mean it is a fair use. And no profit doesn't necessarily equal fair use. So just because you're not making money doesn't mean that it's a fair use, right? So if you're file sharing whole episodes of programs online, then that doesn't really have a good fair use argument, and copying and distributing episodes over a file sharing network is probably not a fair use, even though you're not necessarily making any money, right? A couple specific things for documentary filmmakers. Look, if you're making use of stuff for a particular social, political, cultural critique, that's going to get you a little bit more likelihood that something's going to be a fair use. If it's for a social, political, cultural critique, that is helpful. There's a lot of cases that sort of support your ability to do social, political, cultural critiques. And I have to catch myself at this point because I've told you how difficult it is to predict fair use, but I'm giving you some rules of thumb here. So, there are some good rules of thumb. There are situations where I think you can feel pretty strongly about what you're doing, but I hope I've also given you some steps to understand when you should go talk to attorneys. So a couple keys for documentary film, some rules of thumb. If it's a cultural critique, political, social critique, you might have a better fair use argument. If you're quoting from a work of popular culture to illustrate an argument or point, I think a lot of what we saw was that today. You know, we saw the video with the Valentino's ghost. I gave you the example of the documentary from the talking about the way homosexuals were portrayed in popular media in the 1990s type of thing, right? It's quoting from popular culture to illustrate an argument or a point. And then I think, you know, some of these ways to avoid liability I list here, if you are actually relying on fair use, I think it's a good idea to embrace it. It's not a good idea to sweep it under the rug and be like, well, hopefully they'll never find it and hopefully they won't bother me. Just embrace it, and it might actually help you out later on in terms of being, even if you know, you might even be found to be good faith, even if you were found to be guilty of copyright infringement, that might help you reduce damages too. So if you have a legitimate argument, then just say on there, hey, this was from this film, from this studio, from this year. You know, why not go ahead and embrace that and say, look, I'm relying on fair use, and to just, you know, give credit. In fact, in terms of practical disputes that I see every day, because I see a lot of out of the courtroom disputes, a lot of the disputes are just people angry that they didn't get credited, that they didn't get attributed. And so sometimes that can actually save a lot of heartache and save a lot of unnecessary dispute. Oh, and this was the question that came up earlier in the context of trademarks. I said we get to it, and essentially if you capture something in the process of filming, right, and it's, you know, in the process of filming something else, you capture a street musician playing some music, or there's some piece of artwork, and you're interviewing somebody and there happens to be a piece of artwork, right, that goes by. You do not have to falsify reality. You know, if you, and this is really important because we talked about earlier somebody falsifying and changing the Simpsons footage from the documentary we were mentioning to something else, and changing what was really happening, you know, in the back room at the San Francisco Symphony. Well, you typically do not have to falsify reality, so that if you happen to catch some media in the background, but it has to be legitimately not planned. You can't, you know, there can't be any plan, oh, we're just happened to go by here and there happens to be this amazing mural, or there happens to be this amazing street musician. It really has to be legitimately unplanned. And even,
How did that look with the Simpsons thing and Joe and Elsie? Because that just happened. Simpsons just happened to be playing the stage.
right. Right. Well, I don't know. I wasn't the attorney on that case. I mean, and I think part of it is what I said earlier about there's this unfortunate thing, which is that even if you know your rights and even if you exercise your rights, you still have to make practical choices of, do you want to actually get into an argument? Do you want to actually potentially be the person, you know, do you want to try to win that lawsuit? Do you have the resources? And so that might have been the issue there. I don't know.
I thought one of the issues was that once you start asking permission, then you really can't use it as fair use.
Ah.
So that if you were filming and it was there and you accepted it as being part of the scene and you never asked anybody for permission, but once, and it's, you know, and it's any number of things, once you start talking to the person that owns it or the copyright holder, then you can't claim fair use. That was my understanding.
Well, I think there's probably two. So the question was, if you start talking to the copyright holder, does that somehow change your fair use argument? And I think it does come into these cases. It often gets discussed. You know, what were the discussions between the two? And I think it can help you if you did go to the underlying. You know, if you did go to the underlying copyright holder and they refused you, that might actually be helpful to your fair use argument. But I don't necessarily think that it's necessary to go to the underlying copyright holder in all situations at all. But in terms of the basics of the fair use analysis, it does come up. What were the discussions between the two, and was the license offered? It's really not supposed to be, you know, in any of those factors, whether or not those two, you know, the copyright holder and the filmmaker had talked or not, or had there been an offer, you know, was there an offer of a license or not?
But when we buy footage, you
Oh, that's a good point, though, right? If you have, there are situations where you could have signed a contract or made an agreement with somebody that sort of said, oh, hey, you're gonna, even if you had a fair use right, like you're gonna use it under this license, and you can actually give away, and you can actually basically foreclose your right to use something under fair use by signing an agreement that says that. So you do want to be careful with certain licensing agreements, and certain what's that, even viewing?
You're just viewing it. I mean, you're not licensing it yet, but you're going to, you're going to NBC, you're going to something, and they're sending you footage. That the moment they start sending it to you to look at before you license it.
That's true. If there's a situation where if you sign something or you make some agreement that you're not going to use this stuff without getting a license from an entity, like so they say, oh, we won't even show it to you without you agreeing to such and such, that you won't, that you're gonna, without you agreeing that you will license it from us, you will get a license, then you might kind of, you might limit yourself. Although sometimes it's tough for the filmmaker, because if you don't have access, you don't have access. So, but that's the kind of thing, again, where you might have an attorney just look at that agreement before you go into that situation, so that you know that you're still going to be able to rely on fair use, or at least you know what the expectations are.
To that same example, if you found the clip, if they were charging you more than you're willing to pay, and you find it elsewhere, and you've got a fair use, you think you've got a fair use case, can you say, well, I'm going to go this route? It depends on what your contract said with them. It depends on what your contract said. That's, yeah.
Well, I know, for example, there's a lot of public domain footage from the National Archives and other places.
Right.
And you could go directly to them and it's public domain.
Right.
But other footage houses are selling it.
Yes.
And
yes.
so in that case, I think you just go back to the original, because they're taking something that's fair use and they're reselling it, and then asking you to license it.
I have seen that a lot too. I have seen a lot of public domain stuff that you can get from certain sources being resold by others. And so it is really important to be careful, and you could maybe save yourself and make sure you could probably use some stuff that's already in the public domain, instead of having to pay a license for things that you really don't have to license in the first place.
Hi, could you make some comments on the use of YouTubes
Right.
That might be old but not, quote, in public domain, or how do we deal with YouTube?
Well, YouTube, for instance, I used it today they have some rights that you can, I embedded YouTube. I didn't copy those videos from YouTube. I made no copies, right? I just used an embedded version and I played it from YouTube. So YouTube gets its users some rights to embed and reuse videos in certain circumstances. But frankly, the point about YouTube videos is, it's a new distribution medium, but all the same copyright rules apply. If somebody uploads a video to YouTube that's protected, then it's protected. If it's public domain, then it's public domain. And so, I think you exercise the same kind of caution that you would in the physical world. I think that sometimes ownership and who actually owns it, you want to be careful about. Someone might even tell you that, oh yeah, I own it. You have to sort of take that with a grain of salt and just be careful to figure out who you're dealing with.
Is there a layering in it that tells you who was the original poster of those?
There are, like everybody has an account name, and I think over the years they've made you kind of link those with your Google account and things like that, but it's not always, I think, entirely clear who the individual is. The question was whether or not, how you find out the exact identity of a YouTube user, and that's not always the easiest thing to do, for sure. But I think you exercise the same kind of caution, and you have the same rights, in terms of reusing videos for fair use purposes, YouTube videos, just like you would films as well. So I can either, and then sorry, I was going to say using copyrighted material in a historical sequence. Also some last couple really important rules of thumb where, that are likely to be fair use. if you're the only one that has particular footage of a particular cultural moment or a phenomenon, and to memorialize it, or you found this footage and you're making copies of it, and you need to reuse it to preserve a particular moment or a cultural phenomenon, there might be some kind of fair use right. Sometimes copying, reposting, circulating a work for purposes of a discussion or launching some criticism about that work might be protected, but it really depends on the situation. And then I showed you the Alice video. I showed you the 2014 United State of Pop, the DJ Earworm video that we looked at. And this last bullet point is this quoting in order to combine elements to make a new work that depends for its meaning on often unlikely relationships between elements. That is, juxtapositioning works that you wouldn't imagine to be juxtapositioned, like the Buffy versus Edward example. These are the kind of mashup remix examples that are coming around now. Some of those can also be fair use. Where I'm getting these, by the way, and you can go ahead and look at these yourselves, there are a couple of best practices guides, and they were created by a number of professors, and they were put out by American University Center for Social Media. And one is called the Best Practices for Documentary Film Creators, Best Practices in Fair Use for Documentary Film Creators. And the other one is called Best Practices in Fair Use for Online Video Creators. So these are some kind of bullet points of general best practices for fair use for video creators. And I could do a couple minutes on Creative Commons if people want, or I could open it up to questions. It's up to you. Oh, sure.
Could I ask you please to go back and do a little bit more on the historical sequence?
Oh, sure. Well, I think that they're one of the best examples of what we're talking about there. Also, might be something where you're trying to show the historical development of something, and you have to, so you have to actually show the thing. I think that Michael Singh's Valentino's Ghost plays into that really well. You see in his film, you see the 1920s and 30s and these kind of exoticizing or of the Middle East, and folks didn't really know about it, so it's sort of like this land of mystery and magic and things like that, and then it turns into kind of in the 40s and 50s and 60s into sort of this kind of this barbarian sort of narrative kind of a thing, and then it turns into later on kind of the terrorist narrative. And so to show the development over time sometimes, to show historical development of something, you may need to use creative works, and there's just a lot of different examples of that, of the use of historical works and in a biographical context as well. There's a famous case with the Grateful Dead, for instance, where somebody created a kind of a large table book and in there they had over the years the development of their concert posters. And they didn't have, they weren't huge, but this was a big book. I actually saw it later on, and I was a little bit surprised because in the case they talk about it being sort of small thumbnail, like small versions of it, but this was a huge book. But they were, smaller versions, so you could see over time how the artwork developed for the group. And so I think that would also be an example. In that case, that was fair use because it wasn't the original purpose of marketing the concert. It was for the purposes of historical biography. Sure.
And I'm sorry to get specific, but
oh, sure.
my project predates the camera era.
The what era? I'm sorry.
The camera era.
Oh, sure.
So it's not like I'm going to find any footage.
Right.
So I specifically, because I didn't have any money, stayed away from films.
Right.
But now you've got me thinking about looking at films that may show something like that.
Yes.
An event in history. But if I do that, I'm not necessarily transforming it. I would be using it to illustrate the story that was little known.
this is exactly the kind of thing where you might write us, and for anybody who has specific questions, I'll be around to talk, but at the same time, what you do is on our site, there is a contact us form, which is really where we take legal inquiry, the initial legal inquiry as well. We'll get back to you within a few days. We'll let you know if we can help you or not. If not, we'll try to give you some thoughts about where you could go to get help. If we can, we'd give you a timeline and things like that, but that's kind of a specific legal question, and we can talk about that offline. But oh, sure. Yeah, it's actually, I actually have that right here in Compitech. And on this page too, I have a bunch of other sites where you can, search for Creative Commons and openly licensed materials. And as I said, Flickr has over 100 million, both openly licensed as well as public domain photos. Some of them are amazing. They're from various national archives around the world. Incompetech is a great music source. Wikimedia Commons has a lot of photos and things like that are available. CC Mixter has a lot of audio and music that's available. And in terms of Google image search and Bing image search, I'm not telling you to go to Google image search and just search something, it will be Creative Commons. What I'm asking you there to do is you can look at the advanced search techniques in Google and in Bing, and they actually allow you to search the metadata underneath the image, and a lot of times now they're embedding this metadata so that you can know that a photo is Creative Commons license or not, that is open license or not. Absolutely. And so Creative Commons is it's actually this nonprofit organization that created this suite of licenses. And you can see up here, it's like a spectrum, right? On the left is full copyright. You retain all rights. You retain all rights. You're the only person who can make copies, distribute, create derivatives, and publicly perform and display. On the other end is public domain. And that's entirely free. You can do whatever you want with it. Well, Creative Commons said, look, there's a lot of works out there these days. Some people may not want full copyright, but they may not want to give it away for free either. So let's create some default license settings. And all it is it's taking, if anybody's ever heard of open source software, right? Which is where you can it literally means instead of just downloading and be able to use the software, you can modify or adapt and make the software do what you want it to do. Same thing for cultural licenses. It means that you can reuse, you can take an image, video, and you can reuse it under the terms of the license, and you don't have to, right? You don't need lawyers. You actually can work, you can just see what the underlying artist said you could do with it, and you can go make use of it. And so the idea with Creative Commons licenses is they aren't instead of copyright. You keep your copyright. You still own the work. You have the rights under copyright law. But you just you're basically giving a default license to the rest of the world and saying, look, you can make copies of my work, but you need to attribute me, right? And when you attribute, and all Creative Commons licenses require attribution, and we talked about this a little bit, but the things you always include if you find a Creative Commons work you want to use, always put the title, always put the author's name, and then always just put the basic type of license that it's under, and then you've got your attribution taken care of. And in film, that typically means putting it in the credits. And you have to attribute in a form that's reasonable to the medium. So that might be different for a book versus a blog versus a website versus a podcast, right? But a lot of times for film and for podcasts, that means doing something in like the credits of the show. And some of the basic, just to give you an example, it's not all about just giving your work away. Trent Reznor and 9 Inch Nails released their album in 2008, Ghosts 1 through 4, under Creative Commons license, and they had a built-in audience. So yes, they had a built-in audience, but that was the number, even though you could obtain that album for free in 2008, for free from file sharing networks legally, it was the #1 selling album on Amazon. So the point is that sometimes artists, particularly not necessarily the 9 Inch Nails of the world, but maybe there are a lot of up-and-coming artists as well who might openly license part of what they're doing. So you might be a musician, you say, you know what, I'm actually going to say folks can use this song, but they have to attribute me. Or maybe they have to attribute me and they can only use it non-commercially. And then who knows, there might be, your music might get used in a video or something like that, and that kind of gets your work, your music out there. The basic things, though, with Creative Commons licenses, the choices you have, you can say, you need to attribute me. And then the three others are, can this work be used commercially or not? Can you create derivatives or not? And if I reuse your work, do I need to share it under the exact same terms, that is share-alike, that's what the share-alike term is, or can I just use whatever terms I want to share it under? And what that means is, let's say if I incorporate your image into a collage work of multiple images, does the resulting collage have to be under the same open license that yours was under? Do I have to give that resulting collage away under just an attribution share-alike license as well, or not? And so I can make my creativity, I can make it kind of viral in that way. And if anybody's ever heard of open source licenses, there's a license called the GPL. And the share-alike term is a lot like the GPL in that resulting works that use my work, that's Creative Commons license, need to all have the same license terms, right? So, what's that? Oh, derivative. So that means, and these are the 6 licenses that you can use. And the most stringent is number 1, and the most free is number 6. And number 1 says attribution, non-commercial, no derivatives. So no derivatives means, let's say this is an album, and let's say I created an album with a music group, and I say, look, you can use my work, but it's attribution, non-commercial, no derivatives. So maybe what that means is you've got to attribute me, you can't use it commercially or be selling it or selling access to it, and you can't create derivatives. That is, you can't even adapt it. You can't re-record my songs, you can't sample my songs, but it's still not full copyright because you can release verbatim. You can give a copy to a friend, let's say, verbatim in that situation. So derivatives means adaptations.
Could you explain the difference between a derivative and using a transformative use? There seems like a really blurry.
It is a really blurry area,
How is a Ray album transformative rather than derivative when they're sampling it?
Right, and there's a lot, and actually that is actually a really interesting and complicated area of copyright law. The question is, how is a transformative use different, say, than like a derivative and work? And the answer is there's a lot of overlap there, actually. That transformative in many ways often is adding something new or putting the work in a new light. And so sometimes transformative can mean actually a derivative work, but it has to do with you in transformative, you're not just creating a derivative that is just a version of the original for the same kind of purposes as the original. Transformative is really something where you either artistically or physically transform the work.
Make a movie out of a book.
Right.
You're putting it into it's a new purpose, right? So why is that not transformative?
Well, I think that you're saying just simply making a movie out of a book. I mean, yeah.
I'm just trying to.
If the movie is really in the same spirit and it's the same characters, in terms of making the Harry Potter movies out of the Harry Potter books, I wouldn't classify those as, if those were made without permission, for instance, which they were obviously made with permission, but if they were made without permission, I wouldn't think those are not transformative works. They follow along generally with the books and are based on the characters in the books. So there's no real transformation that's going on there.
Just move it to a new medium doesn't count.
No, just moving it to a new medium doesn't make it a fair use, yeah. But I think I want to go ahead and leave it there, and we can ask any other questions that anybody has. I'm glad to answer, and thanks for having me out today. I really appreciate the chance to come up here and talk to you guys about copyright and fair use, and hope you'll stay in touch with new media rights. We also had maybe did it already go around the sign-in sheet or whatnot? Okay, so we have like a newsletter, and if you want to get that, it's every 6 to 8 weeks. We talk about new guides that we have and resources, so feel free to sign up for that as well. But thanks again for having me. Sure, the question.
I
So fair use, this is an argument that lawyers have as well, but technically it's a defense. So technically it's a defense you raise once you're sued in a courtroom and you say, look, this was a fair use. And it's what's called an affirmative defense. So you say, okay, you're suing me for copyright infringement, but I'm telling you I think this was a fair use. However, what I think, that's true that it's a defense, but I think it's a mistake. Sometimes the mistake that lawyers and other people make about fair use is to say, well, then that means we shouldn't think about it until we get into a courtroom. Because that's a costly scenario not to think about it. And I think that it's worth thinking about before you end up in the courtroom. And that's why it's worth talking about and thinking about a little bit as a filmmaker. But technically, it's really, I would say it's both. It's a defense and it's something that you really is a right, because it's not really worth anything. It's an important safety valve, but it's not worth anything unless people are actually exercising their right to use it. Sure.
So that film you showed earlier with one of your clients, I'm wondering how much your organization charged to work with him on a project like that?
Oh, well, most of the work, I think everybody you saw, most of the work I wouldn't talk about anybody specific, but yeah, most people we either work with for free or for very low cost, and typically even a feature-length film, in terms of a fair use review, wouldn't be more than a couple $100s. So typically we keep it as reasonable as possible and try to fit to people's budgets. And but most of the time we're actually most of the work we've done over the years actually has been pro bono.
Cool.
So in fact, that's, if I do mention one more thing, I guess I'd say, just to remind, we're not a private law firm, we're actually a nonprofit. And we have a lot of folks, we have hundreds of people who are sort of supporters and members, and that ranges, some people might give $25 a year or a couple hundred, depends on whatever they would want to give. But you're welcome to, we really invite you to become a supporter, and it's a way for us it's a way to have a resource for independent creators that is there when you need to write an attorney and have somebody at least write back to you. An attorney will write back to you within a day or two typically when you write to us. And to provide that service, we do it on a very shoestring budget, but we're grateful if you know foundations or you know individuals that want to support this kind of work for artists. Please do get the word out for us and think about becoming a supporter too.